Happy Friday. One more privacy chat. Thanks for all who pay attention to our informal conversations, sometimes just some of my thoughts and sometimes a VIP special guest when the topic is one that really takes a bit more expertise. And this is a pretty complicated one. So I'm super excited to have with me an old friend, Nancy Libin. Nancy, many of you know from early days as a leading privacy and security partner. Maybe you know from her days playing a senior privacy role at the Department of Justice. And today, one of the leads at Davis Wright and Tremaine, a great law firm, which I hadn't quite realized is right across Franklin Square Park from my office. One of the nicest squares, for those of you who are visiting DC next week during IAPP, if you're roaming around, is Franklin Square Park. Really has become quite lovely. The Washington Post, that beacon of democracy, still, I hope, is immediately across. Davis Wright is in that building. There's a phenomenal museum. For those of you who are FTC kind of geeks, the Museum of the Living Word has a section on deceptive words, and it's an interesting kind of unusual museum. The famous editorial writer and author Tom Friedman, his spouse is a philanthropist, and this is one of her big projects. And of course, FPF is on this square as well. So Nancy, we are gathering people here to talk a bit about a rule, an executive order, and then a rule that just became effective on April 8th. We just got some new guidance on Friday. You and the team wrote up some of the interesting takeaways. I know people have not had a lot of time to digest the new takeaways from this executive order focused on data going to foreign adversaries, meaning China and Russia and some other countries. If you are unaware of this in general, please hang up right now, go start reading it, because there are penalties of criminal time up to 20 years. I used to think that's tough, but evidently we can just deport you from this country, even if you're a citizen, to a foreign prison. So I don't know, 20 years is pretty scary. Not usually what privacy and data protection and AI folks, think about when we do our work. So think about it. But we're going to get a little deeper for those who are a little bit familiar with the issue. And Nancy, what did we learn? I mean, the big thing we learned is that many people hoped that the new administration, given that they're canceling executive orders or delaying, executive orders, some may have hoped it would just be canceled. Not that maybe people don't agree with the spirit of it, but that it's a big, significant, complicated, huge contribution of effort, and maybe it would be on the list to be revoked, and it was not. Others were lobbying for delay, just for more time to do compliance. We didn't really get a delay, but we got a little bit of margin. Can you kind of jump in on what did they do in terms of giving people a little bit more time to comply?
Sure. Yeah. And thanks for having me. It's great to be here with you, Jules, and your audience. Well, that's right. Last week, DOJ provided some compliance guidance, some FAQs, and also made clear in an update to its some information about its enforcement that it would delay for 90 days until July 8th enforcement of civil violations, provided that companies engage in good faith efforts to comply in the interim. And as I said, it also issued some FAQs and some compliance guidance that it hopes will facilitate companies' efforts to do that. There's still some unanswered questions, of course, that DOJ is committed to providing guidance on going forward. But this 90-day delay, again, until July 8th, applies only to civil violations. And so long as the company's acting in good faith, DOJ reserved the right to still pursue enforcement actions during this period for any egregious willful violations, which presumably are dealt with through criminal penalties, which, as you noted, can be up to 20 years in prison or up to $1 million in fines.
So good faith, us legal and compliance people get nervous if we don't see exactly what we need to tick off, because maybe good faith means, you thought about it and you sent around some emails, and maybe it means, I don't know, what does the DOJ really think it means if they take this issue as seriously as they seem to? So what can we say about what boxes I should have had to tick, or practical actions I might need to have taken to kind of be somewhat comfortable that I've made a good faith effort?
Yeah. So just to remind everybody, this is a rule that requires U.S. persons, which is defined in the rule, who knowingly, and that means or should have known, you have reason to know, that you have entered into what's called a covered data transaction with what it defines as covered persons or countries of concern. And so we can go into what all of that means a bit more based on, some of the new information DOJ has provided and how it's going to interpret those terms. But to get into good faith compliance, the first thing you really need to do is review your data flows to determine whether or not you are processing any of the two types of covered data. One is government-related data, and the other is U.S. bulk sensitive personal data. And the rule defines what those terms mean. And you need to determine whether you're processing any of that data, whether you're making that data available to any other parties, third parties, vendors, what volume of such data you maintain, because that is going to be an issue in determining whether you trigger the rule, and who are the entities to whom you make that data available. That is really a key issue. So know your data. That's something that should be familiar to any privacy lawyer. And then going through are you engaging in any of the covered transactions? To determine whether you are, you're going to need to look at whether your employment agreements. So I should say the 4 covered transactions are data brokerage transactions, which are any transaction that involves making available personal data that's covered by the rule to any recipient who did not collect that data directly from the person to whom it relates. Those transactions are absolutely prohibited. And so that it is imperative that you identify whether you're engaging in any data brokerage transactions. The rule also covers certain investment agreements, transactions of data that correlate with or that are associated with investment agreements, employment agreements, and vendor agreements. So reviewing your agreements with third-party vendors, with third parties and vendors, with employees, including board directors, and also any investment agreements that involve obtaining ownership interest in U.S. real estate or U.S. entities. All of those agreements, you're going to have to conduct an inventory to see whether any of those meets the requirements of the rule.
So a lot of people may have looked at this thing and said, well, I'm not a data broker, and I don't do business with the government. And of course, as we know, people get swept up sometimes into this whole data broker thing because they have some ed tech relationships where because they advertise or they sell advertising, their data may end up in all sorts of third-party exchanges that are sometimes pretty porous for who can participate in them, or just don't know necessarily who are the participants. It's not that difficult to get a seat or to do business with an agency that has a seat. And obviously there are some very large Chinese advertisers. In fact, some of the big names are actually huge advertisers, and that's how they get and kind of continue to drive a lot of their eyeballs. So we probably do need a caution that don't just assume you're not captured here because you aren't sort of a major cloud provider to a government agency. On that ad tech note, I'm always interested in what one might learn even to use elsewhere, right? We always want good definitions because we see IP addresses, being used and categorized and called personal, called not personal. We see email address. I think most people understand that's personal, but when the government officially puts out a definition of what is health data, what is an inference, what is defined as personal, it's A, relevant for this, but B, maybe what they'll use elsewhere, or maybe what we might point to if we're trying to argue that a federal or state definition, should be consistent with what the wise experts or what companies are already having to categorize and do. So I want to look at that for a second. But before I do, the other good faith item that jumped out to me, you mentioned, starting the process of making sure contracts have the necessary language. I was struck by the very specific point that good faith meant that you are, I can't recall if it says you were like fully compliant or you were working on the CISA requirements, the cybersecurity agency, which has specific requirements around this sort of data, and that may or may not be, something people have looked closely at. Wonder what your thoughts were on some of the CISA guidance.
Yeah, absolutely. So I mentioned that data brokerage transactions are prohibited. There are three other types of transactions that are restricted. And those are the vendor agreements, the employment agreements, and the investment agreements. And if you are engaging in a restricted transaction that involves one of those three, it doesn't mean that you're not prohibited from engaging in that transaction, but you must take steps to mitigate the national security risk that those transactions pose. And so what the rule requires is that you comply with certain, you implement certain security measures that CISA has identified as being suitable to mitigate the national security risks. And of course, it depends on the nature of the business, the size of the business, and what kind of data you're transacting. But CISA outlines sort of three buckets: organization level requirements, some system level requirements, and data level requirements. They will be somewhat familiar to those in the cybersecurity field, inventorying all your assets, designating somebody responsible to implement the CISA program, remediate any known vulnerabilities, again, documenting and maintaining vendor agreements so that you're aware of who has access, implementing logical and physical access controls to systems and organization level assets, and then some familiar, actions that will be familiar as well to privacy lawyers: data minimization, encrypting data using privacy enhancing technologies. It's important to note that the rule treats as covered data any data that is de-identified, pseudonymized, encrypted, or aggregated. That is all considered to be within the scope of the rule. CISA has particular requirements around encryption that you need to follow in order to take data out of the scope of the rule. And so if your data is encrypted, don't assume that you're in compliance or that you're out of the scope of the rule. You're not, and you need to make sure that you take a look at the specifics of these requirements to ensure that you can bring yourself into compliance.
Yeah, and for where the identification is relevant, it's interesting to look at the language that CISA uses for guidance around, what does it mean for data to be de-identified? And there's even a sort of section around using sort of trusted execution environments or kind of clean room, and obviously points out that if one of the covered parties is one of your trusted, environment players, well, then that kind of undermines the entire concept. So that does make sense, but also I think for those who want to be thinking a little bit more broadly about clean rooms, we all took note of the blog that the FTC did a number of months ago, a blog that is still up despite others that are down in terms of business guidance, showed some of their skepticism around clean rooms. And in a call we hosted with some of the staff who wrote that blog to kind of just get into a little bit more of an understanding, they were very much coming from the cybersecurity point of view, and they pointed out that you need to treat the clean room or other relevant parties who maybe you have a contract with, and so you're thinking like that's fine, as potential attackers. And what do you have to show, even though you might have an interesting technical matching process, but you're relying on the fact that, well, it's in another party's hands or it's in the clean room hands, and you might not be thinking of those folks as sort of potential attackers. And do you have like proof that somehow you've prevented them, either technically or maybe I'd argue with appropriate contractual or other measures? But sometimes I think industry comes to that with, well, we've set up a structure and it's legally doing this or that, and very much the FTC framework coming from more of the cybersecurity point of view, who are the potential attackers, and we don't take off the table the interested parties. And of course they know that in some other cases, some of these parties actually have data businesses of their own or, other financial incentives. So they're, ready to assume the worst unless you're able to show. And so CISA, maybe to no surprise of those who come to these things with a cybersecurity, perspective, sometimes us law policy folks, well, we got a good contract, so we think, we've covered it. And the cybersecurity people are reasonably far more skeptical about that. I thought it was helpful, given the definition of health data, given that health data is covered. It's certainly not HIPAA only data. It goes much more broadly. But I thought it was helpful where they indicated that no, they're not worrying about inferences. Right? That's been such an issue in a lot of the state legislative debates. What other takeaways did you get from the either the FAQs or the compliance guide that they published that might be helpful for people?
Yeah, I think that just to go back to something you mentioned earlier, Jules, about the data brokerage transactions and the rules impact on ad tech, I think that is something that I don't know if it's surprising to people, but I think it could be surprising to some who think that they're not likely, website publishers who think that they're not likely to be caught up in the scope of this rule. So I think that's one issue that the FAQs and the compliance guide emphasized again to make clear that this rule is because both U.S. sensitive personal data includes IP addresses, device IDs, advertising IDs, cookie data, and the like, that's available to third-party advertising networks or third-party analytics companies. If those third-party advertisers or analytics companies are covered persons or countries of concern, then you are engaging in a prohibited transaction. And that potentially involves any website publisher, anybody who sells ad space and makes personal data available to website visitors. And so because it's such a complicated ecosystem, I think that really requires companies to do some due diligence to determine who some of these third parties are, what their ownership structure is. And because the ownership can be indirect or aggregate, you're going to have to dig a bit deeper than you might think to determine whether company is a covered person.
Yeah, say something about the ownership and control, right? Because ownership, I think people understood. I mean, may or may not be super easy to always know the ownership information, but okay, you got to know if your partner or your vendors are 50% owned. But whether it's when it's less than 50%, the fact that being a company controlled by, a foreign entity, people were like, I don't really know how I should go do that. That's like a whole complicated, analysis. So it looks like they did give a little bit of breathing room on that.
It does. And they did. So to your point, if a company is 50% or more owned by a country of concern or covered person, that entity is a covered person or and subject to the rule. Let's say a company is 30% owned by a covered person. Well, then you're not technically a covered person. The rule did discuss, though, instances where a covered person, an individual, might exercise some control over that entity. And the FAQs make clear that DOJ stopped short of requiring you to do due diligence to see whether there might be a covered person, a director or somebody of that nature who had control over the entity. But it did acknowledge that control is a factor that raises national security concerns. And if a covered person who is, for instance, a director of an entity that is not otherwise a covered person, that covered transaction that covered person directs may be deemed to fall within the scope of the rule. That's a bit complicated and confusing because it is. And frankly, there's an FAQ number 58 in the FAQs that discussed this and didn't really, frankly, come up with any satisfactory guidance for companies seeking to have crystal clear clarity about what they're supposed to do in this case. It does seem that you do not have to do due diligence, however, to determine who the employees of a company are in order to determine whether that control that I just described exists. And I think until we hear more, I think it's probably makes sense to focus on some of the other issues that DOJ did make clear were going to trigger the rule.
And it does seem that if DOJ itself determines and sort of publishes various lists, which I guess they do, you are on the hook to know who they determined is controlling and then therefore needs to be avoided. And I didn't realize there's also some sort of reporting requirement that if like you turn down a covered transaction as, being something it's not just like, okay, I just won't do that. You now need to report it, which that I didn't expect that.
That's right.
It's not like you were, I don't know, I guess it is going to be considered like, some spy agency reached out and tried to solicit, something from you, and you better now go, speak up about it, or you might be suspect. It does seem like just giving advice that, hey, we can't do this when the business proposes it might get you into, you more of a conversation here than you want to be part of.
Right. And it might not be enough. You need to, within 14 days, as you noted, Jules, report any covered transaction that you reject. And I think that's as much as, to deputize everybody and helping DOJ identify those who might be seeking through evasion or just, overtly engaging in this kind of transaction to sort of identify for DOJ who those entities are. And to your point, Jules, just a moment ago, you're absolutely right. The rule allows DOJ to designate individuals or entities as covered persons If, for instance, in that example we were discussing earlier, somebody was exercising a significant amount of control over an entity that isn't otherwise a covered person, DOJ might decide, well, we're going to designate that entity or that entity a covered person because of the degree of control this other covered person has.
Dennis Evanson asks us, are we saying that if I allow a TikTok cookie on a website, then because it is owned by ByteDance, that would arguably place my website to be in scope of the rule?
Well, full disclosure, my firm has represented TikTok. So I'm going to, let me talk about that in a more general way. I think the first question in any inquiry like this would be to determine what the ownership structure really looks like. And so entities that are branches of companies are considered to be part of those companies. Entities that are subsidiaries or affiliates that don't have that kind of triggering ownership structure will be separate independent entities. And so I think the first thing one would want to do is determine the ownership structure of any company that is placing a cookie on a website. Now, if you determine that the covered person relationship is there, then yes, then you would need to review whether the other elements of the rule were present, whether there was any bulk U.S. sensitive personal data being made available. And
so let's say like location, was part of it.
Let's say location within 1,000 meters, as we discussed, or 1,000 feet or meters, I think it was. Yes, if it met the threshold of 10,000 devices worth of precise geolocation information, then you would trigger the rule, and you would need to, that transaction would be prohibited. And so these data brokerage transactions are prohibited. And I think that's the important thing to remember, that the CISA requirements are not going to remediate any national security risk or mitigate any national security risk that is associated with data brokerage transactions. Yes. The other thing, actually, if I could just have one more minute on that, Jules, this is a really interesting question, and I'm glad it was asked, because it's not just TikTok, or it's not just companies that might have a nexus to China or one of the other countries of concern. If you're engaging in a data brokerage transaction, which is really broadly defined, with any foreign person, doesn't have to be a covered person or a country of concern, it could be a German company, you are required to take action to ensure that that covered person contractually is prohibited from engaging in any onward disclosure or any onward disclosure of the information. And so it's the compliance, the risk assessment and compliance obligations that attach to data brokerage transactions are broader than for the others.
Yeah, and let me just emphasize that, because lots of countries around the world don't have the same, level of restriction for transfers to, for instance, China, which is a major trading partner with, lots of Europeans and elsewhere. And hopefully GDPR and adequacy, had a reasonable number of Europeans looking hard at that, but transfers to the US have been made perhaps a bigger deal under GDPR and Schrems than sometimes the focus on China, although, obviously there's been, equal concern, but not every company in Europe may be as highly aware or sensitized, as I think, we are here because of the debates and controversies. And so that's a lot of contractual work that people may not have considered, again, because they consider themselves not dealing directly with one of these covered parties. Let's wrap up with who are we seeing at companies taking the lead on handling this, because it's got a lot of privacy, data protection type, components to it. Are they, or the chief privacy officers, or the senior legal privacy leads, or other people, who in sort of your world of clients, or just, in general awareness, who's being charged with being the lead on this? Because someone needs to sign off, some senior executive with some kind of compliance related responsibility under the rule needs to be signing off to, or be designated as the responsible person for this program. And that's probably who's going to jail then. So don't line up quickly to take this on.
That was one of the that sort of Sarbanes-Oxley-esque provision that requires a senior official or somebody who's responsible for compliance to sign off on all of this. So this has definitely gotten attention of general counsels. And because the first order of business is to map the data flows and understand them, privacy lawyers, privacy officers are very much involved in preparing for compliance and determining exposure. This also necessarily involves folks in security and IT to understand what the systems and organizational level security measures are that would be required. I do think that, and we were talking about this before, Jules, you made a great point about whether, because this is a national security rule, whether you might have others as well at the organization, whether it's somebody responsible for FCPA compliance or something of that nature. And I think it's important to get, anybody involved in export controls and things of that nature involved in preparing for and complying with the rule, because it does transcend just what we think of when we think of privacy compliance.
We host a lot of sort of peer-to-peer meetings for the senior privacy executives at our member companies. And what I'm seeing is certainly many of the privacy leads taking either a lead or a significant, role with others, such as those that you mentioned. Some playing a role, but pointing to sort of compliance and ethics or export control type parts of the organization as really taking the lead. One company in one of the conversations said, well, our business unit said that they'll take it on. I said, well, that's great. That's great. But who's going to be the compliance person that then signs off? And they said, oh, well, we actually better look more closely at that, because indeed, none of the compliance people are going to want to be the people authorized at the end of the day if it's been pushed out, to the business unit. Well, thank you. A lot of
Thank you.
Useful insight and much appreciated. And of course, you want to get really deep into this and need help, talk to Nancy directly, because that's among the things they do for a living. So great to have your conversation here. And thanks for joining me, and look forward to seeing you around during the IAPP week activities here in DC.
Thanks, Jules. Thanks, everybody.
Thanks all.